ठीक है ठीक है. Good afternoon, sir. I mean, good evening, sir.
Good evening, madam. कशा आहात आपण?
नमस्कार.
नमस्कार.
Hello, sir.
Hello.
How are you, sir?
I am fine.
Good evening, sir.
Good evening, madam.
Yes, sir. Very nice to see you, sir. Thank you so much for accepting our invitation, sir.
It's my pleasure.
Thank you so much, sir.
As I usually tell you, you
Yes.
are busy today.
Yes,
Karishma.
sir. Yes, sir.
Yes.
There was an international panel discussion with us, and
Okay,
we had guests from New Delhi, Mumbai, and Hyderabad.
Okay. First
Yes.
of all, congratulations to you and your team.
Thank you so much, sir. Thank you so much.
My senior is delivering lecture today.
Yes, sir.
Advocate Daitadak, sir.
Yes, sir.
Thank
Sure,
you.
it is going to be a wonderful treat to us to listen to him, sir.
Yes.
Thank you so much, sir.
You usually practice in revenue.
Yes, sir.
Yes.
We're waiting for him only to join.
Okay. There is a opening of IPL tournament, cricket tournament.
Okay.
So I was supposed to leave for the tournament. Two High Court justices are there.
Okay.
Justice Makran and Sanab sir.
Okay.
The program is at 6 p.m. today.
Oh, so you're supposed to go now? You just
Yes. I told Karishma.
Yes.
That I will just start and will leave.
Okay, sir. That will be fine, sir.
Ma'am,
Yes.
sir had joined guest.
Yes.
Yes.
Hello, sir. Welcome, sir.
Hello. Good evening.
Good evening, sir.
Good evening, sir.
Good evening, sir.
Good evening.
मी आताच भारतीय विद्यापीठ उज्ज्वला मॅडम आणि त्यांच्या सगळ्या सहकाऱ्यांचं अभिनंदन केलं. म्हटलं आमच्या सरांचं लेक्चर आज तुम्ही ठेवलंय. इट्स माय ग्रेट प्लेजर.
बार काउन्सिलचे व्हाईस चेअरमन आहेत आपल्याबरोबर.
मी जरी बार काउन्सिलचा व्हाईस चेअरमन असलो तरी तर तुमचा ज्युनियरच आहे.
पदाधिकारी आहात, संघटनेचे पदाधिकारी आहात तुम्ही आता.
येस सर.
Karishma, am I audible?
Yes, ma'am, you're audible.
Yeah. Let's
Ma'am, shall we start?
Yes, of course. Sir, with your permission.
Okay. Yes, sir. Sir, shall we start?
Yeah.
Yes.
Okay.
Karishma ma'am, your voice is not clear.
Okay. Am I audible now?
Yes.
Okay. A pleasant evening to one and on behalf of Bharati Vidyapit, deemed to be university, New Law College Student Progression Cell, I, Karishma Pushkar Patil, Assistant Professor, New Law College, Pune, take this privilege to warmly welcome everyone for webinar on very important topic, that is reading of 712 extract and all important provisions relating to land revenue, organized by Student Progression Cell of New Law College, Pune, in collaboration with Bar Council of Maharashtra and Goa. Before we move to the enlightening session, I take this delighted opportunity on behalf of Bharati Vidyapit, deemed to be University, New Law College, Pune, to wholeheartedly welcome today's eminent resource person, Honorable Advocate Jagdish Dhaitadak Sir, Senior Advocate at District Court, Pune. I would also like to welcome our respected guest, Advocate Rajendra Umap Sir, Vice Chairman, Bar Council of Maharashtra and Goa. I further extend my greetings to our Honorable Dean and In Charge Principal, Dr. Ujwala Bendale Ma'am, and all learned faculty, my dear students, and all those who have joined us for the webinar today. Now, may I humbly request our beloved Dean and In Charge Principal, Dr. Ujwala Bendale Ma'am, to give welcome address for our guest. Over to you, ma'am.
Thank you so much, Karishma. Good evening, everyone. Good evening, sir. And good evening to one and all. Welcome to this webinar on reading of 712 extract and all important provisions relating to land revenue, organized by Bharati Vidyapit's New Law College Students Progression Cell in collaboration with Bar Council of Maharashtra and Goa. Today, it's my honor and pleasure to welcome a very versatile personality of the law fraternity, and he is Advocate Jagdish Dhaitadak Sir, Advocate Pune District Court and Sessions Court. I also take this honor to welcome Advocate Rajendra Umap Sir, the Vice Chairman of Bar Council of Maharashtra and Goa, and all the other dignitaries who have blessed us and graced us. Now, today, I'm here to formally introduce you to Bharati Vidyapit. Sir, the institutions of Bharati Vidyapit were accorded deemed university status in the year 1996 for its academic excellence. Bharati Vidyapit is accredited with A+ grade in 2017 by NAC, and it has category 1 university status by UGC and is ranked 68th by NIRF. The academic excellence of Bharati Vidyapit has been possible only because of Honorable Dr. Patangrao Kadam Saheb, the founder Bharati Vidyapit deemed to be university, who at the age of 18 years decided to establish Bharati Vidyapit as a distinct educational institution. Today, Dr. Patangrao Kadam Saheb is the guiding star for whole of Bharati Vidyapit fraternity. As well, today, under the excellent guidance of our beloved patrons, Honorable Professor Dr. Shivajirao Kadam Sir, Chancellor Bharati Vidyapit deemed to be university, Honorable Dr. Vishwajit Kadam Sir, Pro Vice Chancellor Bharati Vidyapit deemed to be university, Dr. Asmita Tai Jagtap, Director Bharati Medical Foundation, and Professor Manikrao Salunke Sir, Vice Chancellor Bharati Vidyapit deemed to be university. The New Law College, Bharati Vidyapit, has been consistently ranked among the top law institutes of India by Career 360, India Today, Education Post, and Outlook. So, New Law College has been re-accredited with A+ grade by NAC and has also received Gold Star Award from Bar Council of India. Last year, sir, New Law College has been awarded with Best Law College in India for Research and Pedagogy by IIRF Education Impact Awards, New Delhi. And we are the awardees of prestigious Best Legal Aid Center by Knowledge Streets, New Delhi. So, New Law College aims at training and producing legal professionals well equipped with advocacy skills, meeting up the current industry standards. The students at our organization play a very integral part through not only just academics, but also organizing various events. And running multiple student initiative-based cells, such as the Environment Cell, Advanced Exploration Training of Intellectual Property and Cyber Law Cell, Moot Court Society, Legal Aid Cell, Legal Research Cell, SARAL, that is for labor laws, then Community Development Cell, and Madhyasthata, the ADR Cell, and lastly, the Student Progression Cell. So the student progression cell is an initiative to train the students for becoming more practical oriented and prepare them to become the future advocates, judges, attorneys, solicitors, corporate personalities, and so on. Besides this, the cell aims and focuses on educating and preparing students for court practice, judgment writing, drafting, and presentations, interpretations, and so on. The main core aim of the cell is to boost the confidence of the students and educate and prepare the students to help the poor sector of the society and in order to provide them legal aid. So once again, I welcome you, sir, and I express my heartfelt gratitude towards you, sir, for gracing this particular event. And I'm really grateful to you that you have consented to enlighten our students on this very technical but a very, very important topic that is relating to land laws. Thank you so much. Over to you, Karishma.
Thank you so much, ma'am.
Yes.
Now, it is my honor to introduce Honorable Advocate Rajendra Umap, sir. Sir is currently serving as the Vice Chairman for the Bar Council of Maharashtra and Goa. He is trustee of Chinchwad Devasthan Trust. He is also the chairman of the Life Care Foundation, chairman of Janhit Pratishthan, Taluka Shirur. Sir was former president at Pune District Bar Association for the year 2013 and 2014. Sir, we are happy to welcome you for our webinar.
Thank you so much. Thank you so much.
Yes. Now further, I'm profoundly delighted to take this opportunity to introduce our eminent resource person for the day, Honorable Advocate Jagdish Dhaitadak, sir. Sir has completed LLB from ILS Law College, Pune in year 1984. Sir is practicing advocate in Pune Court since past 37 years in key areas such as civil matters, land matters, public trust cases, and many more. Sir is invited as resource person and guest lecturer in DES Law College, Shivaji Maratha College, YC Law College, and many other colleges. Sir is invited every year by Yashida Institute, that is Yashwantrao Chauhan Academy of Development Administration, Pune, to train the class 1 officers, UPSC pass students on the topics such as land revenue, laws, and civil law. Sir has delivered lectures to revenue officers in seminars at Kolhapur, Sangli, Pune, Panchgani, and many other places all over Maharashtra. Sir has handled the famous case of Divine Sri Bhimashankar Devasthan and many other trust matters. Sir is on panel of advocate at Pimpri Chinchwad Municipal Corporation. Respected sir, we welcome you. It is true that every person from our law field keenly wish to gain absolute knowledge about understanding 712 extract and important provisions of land law. So today we are fortunate that we are going to learn from the master in the field himself, who has vast knowledge on this topic. So here I request sir to enlighten us on the most crucial topic, that is reading of 712 extract and all the important provisions relating to land laws. Over to you, sir.
It's an opportunity for me to discuss with the subject so far the land law is concerned. You are getting my voice, all of you?
Yes, sir. Yes, sir.
So the subject we have given, the land laws we have learned so far the LLB is concerned for whole of the year. And we have to discuss this subject for a period of 45 minutes. Now, the subject for discussion today is that 712 extract, how to read, as well as the important related provisions so far the land revenue is concerned. Now, we have to learn, because the madam told me that most of the students in Bharati Vidyapit Law College are from outside Maharashtra, and it will be better to discuss with the prominent provisions, as well as we will be discussing English only. Now, what is the importance so far the property is concerned, that property is a security for life as well as a cause of a dispute, and therefore the record of rights of the property will have to be updated and it is to be maintained properly. To safeguard the property, record of right must be hello.
Yes,
Record
sir.
of right. To maintain and safeguard the property, record of right must be updated. Therefore, we have to see the brief history so far, how the record of right evaluated and how it is developed. In nutshell, we have to see that in the beginning there was no any record, but how it was developed, that initially there was the system introduced by the Sher Shah, one of the minister in 1540. Subsequently, it was the Todarmal who has introduced the system. So far, the survey record is concerned. He was in the era of Akbar. Subsequently, Malik Ambar. Then thereafter, it was a Maratha Empire. Subsequently, the Aurangzeb, Shah Jahan, Aurangzeb, and so on. Thereafter, East India Company. Now, we'll be discussing so far the history is concerned. Instead of that, we have to see that initially there was a survey department, and survey department was used to maintain the record of rights. Subsequently, that survey department was abolished in 1901. Before that, we have to see that how the earlier land law, that is Bombay Land Revenue Code, came into existence. It was in 1879, because previously the Inam Commission was established in 1852 to analyze the inams and watans given by the then rulers, that is Rajas, and to recognize the properties in the name of the concerned person or the further people of that watandar. Subsequently, when the watan properties were there, the Inam Commission has submitted its report to the government, and then thereafter the Act of Hereditary Offices Act 1874 came into existence. Then subsequently, so far, Bombay Land Revenue Code applicable to the state of Bombay up to 1960. It was made applicable up to 1966, that is present Maharashtra Land Revenue Code came into existence and was made applicable in 1966 only. Now we have to see the important provisions and types of record. Before going into 712 extract, we have to see, to maintain the record of right, there are as good as 21 forms maintained by the Revenue Department. And out of these 21 forms, we have to see 7, 7A, and 12. These 3 forms we have to see for to how to read the 712 extract. In colloquial language, we used to express as 712 extract. In fact, it is 7, 7A, and 12. Now, so far the 712 extract is concerned, in the beginning, we have to see that there are columns and hello.
Yes, sir, you are audible.
Yes.
Yes, yes, sir.
No, what I meant to say that I would like to show some 712 extract. Therefore, I was. Are you
Yes,
getting
yes,
it?
sir. Yes, sir,
Yes,
we
sir.
can see.
Yes, sir, we can see.
Just to show this, the 712 extract, I would like to show to the left hand side. It is the. I am just showing the number now.
Mhm.
It is the number of the property in column number 7, 7A, and 12. How we have to read, and along with this, we will be discussing some provisions of our land revenue is concerned. Then, in the upper part, the survey number was written. Subsequently, when the consolidation scheme was made applicable, it converted to gut numbers. Now, another column is there, which reflects the occupants. There are 3 types of occupants. occupant class 1, occupant class 2, and government lessee. Now we have to see what is occupant class 1, occupant class 2, and government lessee. Then in this matter, if we see the further columns so that we can discuss so far occupant class 1, occupant class 2 is concerned. Now I would like to request to all the students, those who are from outside Maharashtra, the form may be different. Here in Maharashtra, 7A and 12 is there. In the respective states, the number could be different, but record of right is common. Therefore, when the students will be going for practice and all majority disputes are so far the property is concerned, therefore, the record of right will have to be read and understood very properly. Now, the another column is there, which reflects that is occupant class 1, occupant class 2, and lessees. Occupant class 1 means the person who is holding the property without any restriction. Occupant class 2 means a person who is holding the property with some restriction. That is, he could not alienate the property, he could not transfer the property without prior permission of the concerned district collector. That is occupant class 2. At the same time, as and when there is written that occupant class 2, in the other right column, that is 7A of the 7th extract, there are conditions mentioned in the other right column. Those conditions are, as and when it is mentioned at occupant class 2, the conditions are the unalienable property, it means impartible tenure. Then if somebody wants to transfer the property, then occupant class 2 has to take permission, and then only he could transfer the property. Therefore, when the survey number, gut number, and then the occupant class 2, occupant class 1, मराठीमध्ये त्याला असं म्हटलंय भोगवटा वर्ग 1 आणि भोगवटा वर्ग 2. आणि इतर हक्कामध्ये इथं असं म्हटलंय की नवीन शर्त तब्दील करण्यास बंधन असलेली अथवा required permission घेतल्याशिवाय ट्रान्सफर करता येते. Now another point mentioned in that, some of the times in the 7th extract, the name of the property is being mentioned, the local name. So many people in Maharashtra used to name that this is the काही वेळा ते देवाचं एक छोटंसं मंदिर असतं खंडोबाची पट्टी. They used to name the property, there was some column was there. Then subsequently the type of watan and inam, because there was previously the inam and watan which was introduced by the then rulers as well as by the British government, and subsequently the inam and watan abolition act came into existence. Then as well as there are 6 types of inam. Out of these, relevant for the purpose today will be that the record of right, how to refer to. Then in this matter, that inam class 3, the village form number 3 is maintained for that. Then so if anybody wants to see that whether this property is inam property, Devasthan inam property, that is class 3 property or not, then in that case, the talati who is holding the record, the village form number 3 is being maintained. Now, so far out of Maharashtra is concerned, the number can be different. Here in Maharashtra, village form number 3 is for the inam varga 3, that is Devasthan inam. Therefore, ignoring the number given herein, the respective states will be maintaining the record, but number could be different. Therefore, so far other watans are concerned, that is register number 1C. Other than inam, Devasthan inam, if we would like to see that which type of inam or which type of watan it is, then in that case, we have to go for the register which is maintained under form number 1C. Now subsequently then, the record comes that is 8A extract, that is the khata extract. The person who is holding the properties is all the lands are being maintained and mentioned in the 8A extract. Now the important form, that is 6D, that is as and when there are changes in the record of rights, those changes will have to be numbered, what we called as mutation entries, and those mutation entries are maintained under form number 6D. Then if we consider this, the another column is given, that is acre and gunta. Now it is hectare and R. Below that, Pot Kharwa means the land which is not cultivable and total of the land. Then below that, assessment. Then you may be surprised that some Inam lands given by the British government or by the government to the Devasthan, those Inam lands can be assessment free. And as and when the land is assessment free, that land could not be transferred. Therefore, we have to see that whether it is with assessment or without assessment. Now, furthermore, we have to see the column number, Kabjadar column, popularly we call the ownership column. But the real name is Kabjadar column. Reason behind this is that though we have purchased the property by registered instrument or by registered sale deed, we have purchased right to cultivate the property, and the superior owner or superior holder being the Union of India, and for that purpose we are paying the assessment to the government. Therefore, we have called in the extract, that is point number 7, that is Kabjadar. And then thereafter, the another column, that in Kabjadar column there is 2 types, that is superior holder and inferior holder. The superior holder is above the line. Now, presume for the sake that ABC is the superior holder. Under his name, one line is marked, and below the line, name of other person is mentioned. He is inferior holder. Therefore, superior holder used to give that property to anybody, that is Miras Patra and all these things, for permanent long lease. Then subsequently that comes to that other right column. इतर हक्क आपण म्हणतो. In other right column, the rights of tenants, rights of lessees, rights of mortgages, rights of encumbrances, that is society, bank, and Pathasamstha, those are mentioned in the other right column. And the last one, that is cultivation column, that is form number 12. In form number 12, the person who cultivates the land, previously there was a column, that is year is mentioned, say that is 2020 to 2021. Then thereafter name of the cultivator is there. Then subsequently mode of cultivation is there. Then season, that is Kharif or Rabi. Then source of water, type of crop, and again lastly the name of cultivator is mentioned, that is cultivation column. Now, as and when if we refer to the main thing we have to discuss so far, the record of right is concerned, that is as and when there are changes. If we see that heirship entry, suppose a holder expired, and if he is a Hindu person, then in that case Hindu Succession Act will be made applicable so far the entries or change in the record of right is concerned. Then every change, there can be a change due to succession. It may be Hindu succession or Mohammedan succession. It may be a testamentary succession, or it can be by way of a gift. It can be by way of an exchange, or it can be by way of a hiba. That is Muslim, in the Muslim law, there is a gift is called as hiba. Then subsequently, as and when entries are taken in record of right, that is heirship entry, those heirship entry previously used to note that if suppose a holder property, that is Mr. A, is expired, and after death of A, the name of the successor of his legal heirs will have to be recorded in the record of rights. After recording that, the eldest person in the family is being called as joint family manager, joint family karta. Then below his name, eko म्या असं मराठीमध्ये लिहिलं जायचं. As soon as if it is mentioned, the disputes are being arose after the death of that joint family manager. Some of the times that dispute is arose on the point that the legal heirs of that concerned manager only are entered in record of rights, not all the brothers and sisters. Therefore, the care will have to be taken that as and when there is an entry of Karta family, then all the names of the members of that joint family and members of that family will have to be recorded in the record of right, so that it will not be a dispute in that matter. Then subsequently, if we go to that when there is a tenant in the property, the name of the tenant is mentioned in the other right column or the mortgagee in possession. If suppose that tenant, if purchase the property under the provisions of some tenancy law, then restriction to transfer that property is mentioned in the other right column. That is restriction under section 43 that property could not be transferred without prior permission of the district collector or by the subdivision officer. Now, if we see that this record of right is being maintained by whom? The record of right is being maintained by the village officer, that is called Talati. Now, Talati is given some villages that is called as Saza, S-A-Z-A, and who is in charge of that Saza? Then superior officer, we have to see the hierarchy of the revenue officer so that we can go for some important provisions. Then superior officer, then Talati will be that circle officer. The circle officer who is in charge of the Sazas, one or more Sazas, that is called circle officer or circle inspector. Then subsequently, the one or more circles are called Taluka, which is headed by the Tahsildar of the Taluka or the Mamlatdar of Taluka, who is assisted by the additional Tahsildar, Naib Tahsildar or resident Naib Tahsildar. Then two or more Taluka will be known as subdivision, that is headed by the deputy collector, who is called subdivisional officer, and two or more subdivisions is called the district, is headed by the district collector, assisted by the additional collector of the concerned district. Then subsequently, two or more districts is called division, that is revenue division, which is headed by the divisional commissioner and assisted by the deputy commissioner, additional commissioner, and so on. Now, this is the hierarchy of the revenue officers. Now, we have to see that so far the provisions of regarding cases are concerned, as well as some important provisions so far to record of rights are concerned. Everybody knows that some of the students may have the agricultural lands, and in that agricultural lands, if somebody wants to construct some farmhouse, then in that farmhouse, nobody could say that I can go there and I can start construction as I wish. That is not the case. Now, so far land revenue code is concerned, under section 41, the permission will have to be taken from district collector. There is restriction for area is concerned. In 1 hectare, we can build up the farmhouse up to 15-meter height, not more than that, and 250 square meter, the area will be for that purpose. Then, considering that restriction, if we will not consult to our client in the future when you will start the practice, then it can be illegal construction so far, though the land is owned by the concerned owner. Then another provision comes that as and when you construct the property, so far farmhouse or any room or any house is concerned, or if the holder wants to change the use of land. In short, other than agriculture, if you would like to change the user of land, that is non-agriculture use for residential purpose, non-agriculture use for commercial purpose, non-agriculture use for industrial purpose, and so on. Then in that case, application will have to be filed under section 44 to the concerned district collector or the officer delegated with the powers by the district collector for the permission to change the use. Now, the provision given in section 44 that if we apply for non-agriculture use permission and within a period of 90 days, if the permission is not granted and no query is made, then in that event, the permission is deemed to have been granted. If there is no communication within a period of 90 days from the date of application, the permission is deemed to have been granted. Then subsequent provision will have to see that as soon as the NA use is started, that is non-agriculture use is started, the concerned user has to pay non-agricultural assessment. NA assessment, what we call, and that period of NA assessment which is fixed for 30 years, and after 30 years, that period could be changed, that assessment could be changed. Now, the other thing we have to see that section 48 is more important so far. Those who will be practicing so far agriculturists are concerned. Suppose you have purchased the property and for the purpose of supply of water, you are trying to dig a well in your land. Suppose while digging the well, there is a store of minor minerals or mineral. Then in that event, though you have purchased the property in the eyes of law, you have purchased the right to cultivate the property and not the minerals below the land. Therefore, government department come into play in that matter and will be saying that it is owned by the government. Though the property you have purchased it, you have purchased the right to cultivate the land, not the minerals below the land. For that purpose, section 48 is important, that is about minor minerals. Then subsequently, section 49, so far the land revenue code is important in the matter, that is water course and pipeline. So many disputes are there in the villages for construction of a water course and for the laying down the pipeline. The permission, the provision for permission is given under that section. Then subsequently, the provision for summary eviction under section 59 of the land revenue code, which can be relevant provisions so far the relevant land laws are concerned in different states. That as and when there is a government land and in the government land somebody is occupying without any permission, in short unauthorizedly occupying the land, then in that case the person could be summarily evicted under section 59 of from the government land. Now the important provision so far is that section 85, that is partition of the property, subdivision of the property. In that case, as and when the agriculturist would like to divide their property, then in that event the agriculturist will have to file an application under section 85 to the Tahsildar of concerned taluka. Then after taking the statements that concerned Tahsildar used to divide the concerned property in the parts, those who are occupant for that, but the concerned division will not be amount to a fragment, because there is a Fragmentation Act in existence and the area of that fragment should not be the permitted area. Therefore, the care will have to be taken for while making partition of that property. Now, section 138, just we are discussing important provision only. Section 138 is in respect of the boundary and boundary marks. That is about an encroachment in the agricultural fields. For that purpose, the prior condition there is that one has to get measure his land so far to demarcate the property, to fix the boundaries, and as well as to remove the encroachment. If after measurement, if it is found that in the map of measurement, the encroachment is shown to the eastern side of concerned property, then the owner in whose land encroachment is caused, he can file an application for removal of an encroachment under section 138 to the concerned Tahsildar or the concerned deputy collector. Now, the important provision furthermore will be the right of way, that is governed by section 143 of the land revenue code. I am just taking the event of that. Section 143 is in respect of if the agriculturist who is at the rear side of the road and there are some other agriculturists to the front side. The person who would like to cultivate his land, which is to the back side of the road, he would like to have access to his land. Then in that matter, for the purpose of access, the road could be given from the boundaries of two survey numbers. That provision is given under section 143 of the land revenue code. Now we have to see what are the appellate review and revision provisions. So far the changes are concerned in 712 extract. I am just showing one extract now. In this extract, some numbers are mentioned and to that number round is made. Hello. Hello,
Yes, sir, we can. Yes, sir, we can see.
you are getting it. In the
Yes,
7th
sir.
extract, the round numbers are there, and so far that round numbers are concerned, those are called mutation entries. And so far these mutation entries could be there in the record of right only when there is a change in the record of right. Mutation means change, and entry means number. As and when the change could be by sale, change could be by heirship, change could be by succession, change could be by mortgage, change could be by exchange, change could be by will, therefore, or by gift also. Then in that event, as and when the change is there, and if that change is not agreed by the concern holder, then in that event, the mutation entry will have to be challenged by way of an appeal. Now, the changes are just now we have discussed. It can be by sale, gift, exchange, mortgage, or otherwise. As and when there is a change, that is mutation entry, that mutation entry will have to be challenged before the deputy collector under section 247 of the Land Revenue Code. And so far section 247 is concerned, there are as many as 2 appeals are provided, because right of appeal is a creation of law. It is not fundamental right. Then subsequently, if appeal is to be filed, then appeal is to be filed within a period of 60 days from the certification of the mutation entry or the decision given by the circle officer or by the Tahsildar. Then if 2 appeals are filed, then subsequently there is a provision of second appeal also, because the first appeal is provided with the deputy collector, that is sub-divisional officer. Second appeal is provided before the additional collector or the collector, and revision is provided before the additional commissioner or divisional commissioner. Now, the provision of review is also there. Before that, the provision of revision, for the purpose of revision, the period of revision is limitation is of 90 days. That is from the date of communication of the order by the concerned court. Within a period of 90 days, the aggrieved party has to file an appeal before the authority, that is higher authority, as per Schedule E of the Land Revenue Code. Under Schedule E, there is a hierarchy of the authority, that is appellate authority. Now, so far section 257 is concerned, that is meant for revision. That is to be filed before additional commissioner, divisional commissioner, and the concerned officers. Now, provision of review is also there. Review. It is given under section 258. So, for review is concerned, it could be filed before the same authority who has passed an order. That time limit for review is given for 90 days, and within a period of 90 days, review could be filed. Now, if we have to see that suppose a party is appearing in the matter, advocate is appearing in the matter, and for some of the dates the party is not appearing, then the authority concerned, maybe the deputy collector, additional collector, or by the additional commissioner, they can dismiss the matter for default in appearance. That provision is given under section 232 of the Land Revenue Code. Therefore, as soon as the party failed to appear, or the advocate of the party failed to appear, then in that matter could be dismissed for default. Then after dismissal of that matter could be restored within a period of 30 days before the same authority under 232 subclause 3, 232(3) खाली परत restore करता है. If we see this provision, then in this matter, so far the 70th extract and record of rights are concerned, we have to see in other right column the important provisions so far, the non-transferability, because while practicing, you have to give the search report also, title report. And in the title report, we should know that what are the contents of the 70th extract or the property card as and when there is a city survey extract. Now, one more thing I would like to explain here. Whenever there is city survey scheme is made applicable in the village or town, the 70th extract is being closed and property card is being opened under the land revenue code only. And there, instead of city survey number or gut number, the number is given will be the city survey number. Then for that purpose also the same provisions are made applicable. So we have discussed on that point now. Therefore, while giving the title or search report, that if suppose tomorrow client came to you and say that, Mr. Advocate, I would like to purchase the property, please tell me whether the person holding the property has marketable title or not. In that event, you have to say, and what you have to discuss and study, the property card you have to discuss and study, that whether this person is holding proper title, is there any encumbrance, is there any right of tenant, is there any mortgage or any clock or any recovery from the bank, and if suppose if there be any, and in your title report there is no any expression made by you, irrespective of the fact that there is in other right column name of tenant is there, then it will be a defective purchase so far that by purchase is concerned. Therefore, while writing the title report, we have to study the record of right very properly. Not necessarily in the 712 extract, but property card and all other record. Therefore, the important issue, so far the practicing law is concerned and land laws is concerned, the record of right, property card is very important document so far the title report is concerned. And if we discuss this regarding the other right column and in Kabjadar column, so for that Watan laws are there, and so far Watan provisions are there, types of Watans are there, that is class 1, class 2, class 3, 6A, 6B means Mahar Watan, Ramoshi Watan, Patil Watan, personal Inam. Now the Inam and Watans are two different things. The Watans are given for remuneration, while Inam is a gift as a reward. Therefore, we should not mix the two issues, that is Watan and Inam. Therefore, if we consider these many things, I think I have tried to explain this within a stipulated period of 45 minutes. If there be any doubt, we can discuss on that.
Yes, sir. Sir, surely I'll just check with the students, as the students are on YouTube link. So I'll just check if there are any questions.
Wait.
Sir, sir, no questions are not raised. Any questions are not raised yet by students.
No question, no query.
No, sir. As they are on YouTube, so they are not they are not texting directly in the message.
Oh.
Okay, sir. So it was indeed the most enlightening and knowledgeable session, sir. Thank you so much, sir, for making us understand all the important provisions related to land revenue and teaching us reading of 712 extract. It was pleasure to learn so many things from you, sir. As we are short with time, we would definitely like to hear you furthermore, sir, like in the next sessions. And it is we are absolutely thankful that you consented to give us this opportunity to hear you, sir. Thank you so much, sir.
Thank you, sir. Thank you so much.
Yes, sir. So here, ma'am, shall we move to vote of thanks?
Yes, please, ma'am. Yes.
Yes. On behalf of Bharati Vidyapit New Law College Student Progression Cell, I take this opportunity to express my gratitude to our resource person, Honorable Advocate Jagdish Dhaitadak, sir. Thank you, sir, for your insights and guidance to all of us present here. Definitely, we got to learn so many things from you, sir. We are grateful, sir. I would also like to thank Advocate Rajendra Umak, sir, who spared time from their busy schedule to grace the occasion. Further, I would like to thank our Honorable Dean and in charge principal, Dr. Ujwala Bendale ma'am, for being the most strongest pillar of support for us. A special thank to all the teaching and non-teaching staff. A heartfelt thanks to all my dear students and everyone who have participated this webinar. Thank you one and all. Thank you everyone. Thank you, sir.
Thank you, ma'am, for an opportunity.
Yes. So here we end our webinar. Thank you.